Hello, friends. My name is Sampa Karmkar Singh. I am Assistant Professor at WBNUJ's Kolkata. Today, we are going to discuss about adoption and maintenance. Black's Law Dictionary defines adoption is a juridical act creating between two persons certain relations purely civil of paternity and filiations. Adopted child is someone who is not the natural child of the parents but has become a true child by a legal action. Adoption in ancient India. In our country, adoption has been practiced for thousands of years. Among Hindus, one of the main motivation for adoption has been the importance attached to producing a son. The son enabled the father to pay off the debts he owed to his ancestors. Adoption entailed both religious and legal processes. Personal laws on adoption. Personal laws of Muslims, Christians, Parsis, and Jews do not recognize complete adoption, as non Hindus do not have an enabling law to adopt a child, those desirous of adopting a child. They can only do that under the garb of guardianship, which is provided under the provisions of the Guardian and Wards Act 1890. The Guardians and Wards Act, according to this act, the child taken in guardianship would not have the same status as that of a biologically born child. It recognizes only guardian-ward relationship. Under this act, the child becomes a ward, not an adopted child. As a result, the child does not have the same status as that of a biological child and also does not have the right of inheritance. One landmark case in this regard is Lakshmikant Pandey versus Union of India. It was held that the Guardians and Wards Act 1890 is applicable as a prerequisite for inter-country adoptions as well. In case a foreigner wants to adopt an Indian child, he or she must first become the legal guardian of the child. When the court is convinced that parents are fit to adopt a child, the state parents can legally adopt a child within 2 years from the arrival of the child in their country, as per their adoption laws. The Hindu Adoption and Maintenance Act 1956. Hindu law treats an adopted child as equivalent to a natural born child. The Hindu Adoption and Maintenance Act of 1956 is applicable only to Hindus because you can see from the name itself, it says the Hindu Adoption and Maintenance Act. The first question which will come to your mind is, who are Hindus? Any person who is a Hindu by religion, including a Veerashaiva, a Lingayat, or a follower of the Brahmo Pratna or Arya Samaj. Any person who is a Buddhist, Jain, or Sikh by religion. And any other person who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu laws. It further explains the following persons are Hindus, Buddhists, Jain, or Sikh by religion, as the case may be, any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jain, or Sikh by religion, any child, legitimate or illegitimate, one of whose parents is a Hindu, Buddhist, Jain, or Sikh by religion, and who is brought up as a member of the tribe, community, group, or family to which such parent belongs or belong. Any child, legitimate or illegitimate, who has been abandoned both by his father and mother, or whose parentage is not known, and who in either case is brought up as a Hindu, Buddhist, Jain, or Sikh, and any person who is a convert or reconvert to the Hindu, Buddhist, Jain, or Sikh religion. One interesting question which might come to your mind is, are the scheduled tribes considered as Hindus? The Hindu laws shall not apply to the members of any scheduled tribe within the meaning of Clause 25 of Article 366 of the Indian Constitution, unless the central government by notification in the official gazette otherwise directs. So, scheduled tribe will not directly come under the term Hindus until and unless the provision which is established by law is fully followed. Section 6 of the Hindu Adoption and Maintenance Act provides the requisites of a valid adoption. No adoption shall be valid unless the person adopting has the capacity and also the right to take in adoption. The person giving an adoption has the capacity to do so. The person adopted is capable of being taken in adoption, and the adoption is made in compliance with all the other conditions mentioned in the Hindu Adoption and Maintenance Act. So it actually Section 6 provides the requisite and the capacity that who can give the child into adoption, who can take the child into adoption, and the child itself. The Hindu Adoption and Maintenance Act of 1956 does not recognize adoption by a Hindu male or a female if such person is of unsound mind or minor. A Hindu male shall adopt a child only with the consent of his wife, except where the wife has renounced the world or is of unsound mind or she has converted to another religion. Section 7 says capacity of a male Hindu to take in adoption. Any male Hindu who is of sound mind and is not a minor has the capacity to take son or a daughter in adoption, provided that if he has a wife living, then he shall not adopt except with the consent of his wife, unless the wife has completely and finally renounced the world, or she has ceases to be a Hindu, or she has been declared by a court of competent jurisdiction to be of unsound mind. So these are the three categories where the spouse, the husband, is not bound to take the consent from the wife. However, in other cases, if there is a married Hindu man, he definitely has to take the consent of his wife mandatorily prior to the adoption. Section 8 talks about the capacity of a female Hindu to take in adoption. Any female Hindu who is of sound mind and is not a minor has the capacity to take a son or daughter in adoption, provided that if she has a husband living, she shall not adopt a son or daughter except with the consent of her husband, unless the husband has completely and finally renounced the world, or he has ceases to be a Hindu, or has been declared by a court of competent jurisdiction to be of unsound mind. So, more or less, if you see Section 7 and Section 8, both are talking about the capacity of a male and female Hindu to take a child into adoption, and the provision is similar to both of them. Section 9 talks about persons capable of giving in adoption. Who can give a child into adoption? Only the father, mother, and guardian shall have the right to give a child in adoption, and no one else. Here, the interesting part is that when we talk about father and mother, it means the biological parents, and it does not include the adoptive father and an adoptive mother. So, suppose you have adopted a child, and if you further want to give the child into adoption, you are not capable to give the child into adoption. It is only the biological father or mother who can give the child into adoption. Apart from them, it is the guardian, and guardian is also defined. Guardian means a person having the care of the person, of a child, or of both his person and property, and include a guardian appointed by the will of the child's father or mother, who is known as a testamentary guardian because he is appointed through a will, either by the father or by the mother, or a guardian appointed or declared by a court. So court can also appoint a guardian considering upon the facts and circumstance of the case. Section 10 talks about persons who may be adopted, the most important section, which talks about that who can be adopted, means about the capacity of the child who is capable of being taken into adoption. No person shall be capable of being taken in adoption unless he or she is a Hindu. Because this act is related to Hindus, the name itself is self-explanatory. It is the Hindu Adoption and Maintenance Act, which clearly says and suggests that it is only applicable to Hindus. Second, he or she has not already been adopted, as we have earlier discussed, that it's only the father, mother, or the guardian who can give the child into adoption. And once the child has been validly adopted, it is not open to be further being adopted by someone else. Can a married person be adopted? A very crucial and interesting question. The answer is provided under Section 10, subsection 3. In this clause, it provides a person to be adopted has not been married unless there is a custom or usage applicable to the parties which permits persons who are married being taken in adoption. Age of person to be taken in adoption. Section 10, clause number 4, it provides that the child has not completed the age of 15 years unless there is a custom or usage applicable to the parties which permits persons who have completed the age of 15 years been taken in adoption. So for both 10 subclause 3 and subclause 4, it is the custom and uses which are of the determining factor. In general, a married person cannot be adopted. A person who has completed the age of 15 years cannot be adopted under the Hindu Adoption and Maintenance Act. However, if their custom and uses provide certain kind of provisions which permits such adoption, it can be done. Section T3, clause number A. It defines customs and uses. What constitute custom and uses? Because sometimes the custom and uses, it has the force of law, and we have seen that in case of age and marriage, it is of determining factor. So it's very important that we should know about what is the definition of custom and uses. Any rule that having been continuously and uniformly observed for a long time has obtained the force of law among Hindus in any local area, tribe, community, group, or family, provided that the rule is certain and not unreasonable or opposed to public policy, and provided further that in the case of a rule applicable only to a family, it has not been discontinued by the family. So the provision is very clear that it should be continuously and uniformly observed for a very long time. Second determining factor is that it is not unreasonable, the rule is certain, and it is also not opposed to the public policy. And finally, it talks about the applicability of certain customs and uses, which is supposed is only applicable to a family, because family to family also custom may vary. But if in that family it has not been discontinued by the family, maybe it can be considered as custom and uses and have the force of law under this section. Section 11 talks about other conditions for a valid adoption. In every adoption, the following conditions must be complied with. If the adoption is of a son, the adoptive father or mother by whom the adoption is made must not have a Hindu son, son's son, or son's son's son, whether by legitimate blood relationship or by adoption, living at the time of adoption. Now, it's very interesting interpretation of son, son's son, or son's son's son. If you see, it actually talks about the 4 generations which constitute the coparsonary. In Hindus, the coparsonary system is still prevalent, and under that, if a male or a female, if the father or a mother, they want to adopt a son, then they have to be very careful. They have to first check that there is no son or son's son or son's son's son. So if you count these people from the person who is the adoptive father or mother, it will come to 4 generations, which constitutes the coparsonary, which is unique in Hindus. If the adoption is of a daughter, the adoptive father or mother by whom the adoption is made must not have a Hindu daughter or son's daughter, whether by legitimate blood relation or by adoption living at the time of adoption. So it cannot be an adopted daughter or son's daughter if the father or mother by whom they want to adopt a child, a daughter, then they have to check that there is no daughter, they don't have any daughter, and also they don't have their son's daughter. So it is only going to the male counterpart. You could see it talks about either their daughter, either their son's daughter. The next provision says if the adoption is by a male and the person to be adopted is a female. Now this provision is for the single male if he wants to adopt the child. The previous 2 provisions were about father and mother, means a married couple. Under this subsection, under this clause, the adoptive father is at least 21 years older than the person to be adopted. So if a male Hindu wants to adopt a female child, then the age gap should be 21 years. If the adoption is by a female and the person to be adopted is a male, the adoptive mother is at least 21 years older than the person to be adopted. In the similar fashion, if a female wants to adopt a male child, then the adoptive mother should be at least 21 years older than the person who is being adopted. The same child may not be adopted simultaneously by two or more persons, as we have earlier discussed, that once the child has been adopted, it cannot be simultaneously adopted by two or more persons. And it is also not open to the adoptive parents because they are not covered under the definition of father and mother who are capable to give a child into adoption. The child to be adopted must be actually given and taken in adoption by the parents or guardian concerned or under their authority with intent to transfer the child from the family of its birth. In the case of an abandoned child or a child whose parentage is not known from the place or family where it has been brought up to the family of its adoption, provided that the performance of Datta Homam, which is a ritual which is actually performed at the time of adoption, it shall not be an essential practice to the validity of an adoption. So, whether it has been performed or not, that will not have any impact over the validity of a valid adoption. Section 12 talks about effects of adoption. What effects it has when a child is being adopted from one family and it goes to the another family. An adopted child shall be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of the adoption, and from such date all the ties of the child in the family of his or her birth shall be deemed to be severed and replaced by those created by the adoption in the adoptive family. So, once the adoption has taken place and all the provisions are being followed correctly, then it becomes a legally valid adoption. And after that, it is deemed that the child who is being adopted has severed all its relationship with the previous family where the child has taken birth. And it has replaced by those rights which were created through this adoption in the adoptive family. So now he is the part of this new adoptive family and he has no relation with the previous family where he has taken birth. It also has proviso. It provides that the child cannot marry any person whom he or she could not have married if he or she had continued in the family of his or her birth. So this marriage related bar or restriction will still continue no matter he has now severed all his connection with the previous family where he has taken birth and is part of the new adopted family. Still, the bar related to marriage will continue and he has to observe for both the families. So, whom he cannot marry, he cannot marry. No matter whether he has now part of the new family is still in the old family. If he was there, in that case, the members whom he cannot marry, that restriction will still continue with him. Any property which vested in the adopted child before the adoption shall continue to vest in such person subject to the obligations, if any, attaching to the ownership of such property, including the obligation to maintain relatives in the family of his or her birth. This is related to the property rights. Suppose something has already vested before the adoption of the child, something is in the child's name. Then the child will take that property with him. It will continue to vest in such person. Subject to the obligations, there can be some kind of obligations also, which is related to the ownership of property. Sometimes there are some certain obligations to maintain relatives in the family of his or her birth. So that will still continue. And the child will also continue to vest all the property rights which has vested in him or her prior to the adoption. The adopted child shall not divest any person of any estate which vested in him or her before the adoption. The similar way, when the child is adopted to the new family. Now here suppose some kind of property related thing has already vested in some other person. Then this adopted child cannot claim to those property which has already vested in some other person. So the adopted child shall not divest any person of any estate which vested in him or her prior to the adoption. Section 13 talks about the rights of adoptive parents to dispose of their properties. Subject to any agreement to the contrary, an adoption does not deprive the adoptive father or mother of the power to dispose of his or her property by transfer inter vivos. Inter vivos means from a living person to a living person, means a transaction which is between two living persons, right? For example, suppose a deed of sale. Here, the seller and buyer both are alive, and there is a transfer of property through the mode of sale. So, this will be treated as transfer inter vivos, or by will, that is testamentary succession. When we talk about will, it is testamentary. Testamentary succession means where there is a testament, means the person who died, the testator, he has written a will before his death, and the property will be divested and disposed of as per the wishes of the person, the testator who has made that will. So, if a person has the adoptive parents, they have adopted a child, it does not mean that they have lost all their rights to make a will or sell the property or transfer the property inter vivos. So, adoption and the rights of adoptive parents are still intact. But if suppose there is any agreement to the contrary, in that case, maybe it will be taken into consideration based on the facts and situation, and it might vary from case to case basis as well. Section 15 talks about valid adoption not to be cancelled. Very important provision. Because in this provision, it talks about the validity of the adoption, plus even if the adopted child tries to renounce his or her status as such and want to return back to the family of his or her birth, that is also not punishable by virtue of Section 15 of the Hindu Adoption and Maintenance Act. It clearly says, no adoption which has been validly made can be cancelled by the adoptive father or mother or any other person, nor can the adopted child renounce his or her status as such and return to the family of his or her birth. Section 16 talks about presumption as to registered documents relating to adoption. This is a presumptive clause. Presumptive clause means if the matter goes to the court, in that case, what the court will presume. It is definitely subject to challenge, and finally the court will decide on the basis of the facts, situations, circumstances, evidences put from both the sides on the basis of that. However, the court's starting point would be the presumption that if there is any registered document related to adoption, what the court will presume. So whenever any such document which is registered under any law for the time being force is produced before any court purporting to record an adoption made and is signed by the person giving and the person taking the child into adoption, the court shall presume that the adoption has been made in compliance with the provisions of this act until and unless it is disproved. So as I said, that it is always subject to disprove. However, the presumption of the court would be primarily that it has been made in compliance with the provision of this act, unless it has been disproved. The Hindu Adoption and Maintenance Act was amended by the Personal Laws Amendment Act of 2010. By this amendment, it has included a provision granting the right to married women to take a child into adoption. Moreover, the parent of the child shall have identical rights for giving their child in adoption, but only with the permission of the other parent. Therefore, the Act recognized the rights of women as equal to those of a man. Coming to the next part of this enactment, that is maintenance. What is maintenance? It has been defined under Section 3, Clause B of the Hindu Adoption and Maintenance Act. In all cases, provision for food, clothing, residence, education, and medical attendance and treatment. In the case of an unmarried daughter, also the reasonable expenses of and incident to her marriage. Section 18 talks about maintenance of wife. And again, these provisions are applicable only to Hindus. A Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained by her husband during her lifetime. Means the husband is responsible to maintain the wife post-marriage. A Hindu wife shall be entitled to live separately from her husband without forfeiting her claim to maintenance. Now, this is very interesting and important provision which gives the Hindu wife liberty and right, and she is entitled, even if she wants to live separately from her husband, she can do so with her claim to maintenance intact. And it provides certain grounds, certain conditions, certain situations where she can do this. First is if he is guilty of desertion. Suppose the husband is guilty of desertion. That is to say, of abandoning her without reasonable cause and without her consent, or against her wish, or of willfully neglecting her. If he has treated her with such cruelty as to cause a reasonable apprehension in her mind that it will be harmful or injurious to live with her husband. There was clause number C, which has been now removed by the Personal Laws Amendment Act of 2019, which provided leprosy as a ground as well. However, now leprosy is a curable disease, and that's why it has been removed as a ground. Next is if he has any other wife living. Fifth is if he keeps a concubine in the same house in which his wife is living or habitually resides with a concubine elsewhere. If he has ceases to be a Hindu by conversion to another religion, if there is any other cause justifying her living separately, a Hindu wife shall not be entitled to separate residence and maintenance from her husband if she is unchaste or ceases to be a Hindu by conversion to another religion. Section 19 talks about maintenance of widowed daughter-in-law. A Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained after the death of her husband by her father-in-law. So you could see that the responsibility of the wife is on the husband. But once the husband dies, she becomes a widow. And that time, this responsibility to maintain the widowed daughter-in-law is on the father-in-law. There is an interesting case of Tar Singh versus Jasbir Singh in this regard. In this case, the Honorable High Court of Punjab and Haryana, they have observed a lacuna in the position of Hindu women, their property and maintenance rights. Under the existing law, it was identified. When the husband is insane, from whom can the daughter-in-law claim maintenance? The act is very clear. The section says clearly that if there is a widowed daughter-in-law, in that case, the father-in-law has to maintain the widowed daughter-in-law. But what if the husband is insane and not dead? So there is no provision in law if the husband is insane or of unsound mind, from whom the daughter-in-law who does not have any other source of maintenance can claim maintenance for herself. When she has to maintain her mentally ill husband, her condition is worse than being a widowed daughter-in-law. In such a situation, the wife should be deemed to be dependent upon the father-in-law and entitled to maintenance as provided under Section 19 of the Hindu Adoption and Maintenance Act. Based on the above recommendations, the Law Commission of India decided to look into this question, and they came up with the report number 252. This report was titled as Right of the Hindu Wife to Maintenance, a relook at Section 18 of the Hindu Adoption and Maintenance Act 1956. This report proposed amendment to the Hindu Adoption and Maintenance Act 1956 that the right of a Hindu woman whose husband is unable to provide maintenance to her must be protected, and accordingly recommended insertion of subsection 4 under Section 18. And they recommended this clause: where the husband is unable to provide for his wife on account of physical disability, mental disorder, disappearance, renunciation of the world by entering into religious order, or other similar reasons, the Hindu wife is entitled to claim maintenance during her lifetime from members of the joint Hindu family of the husband, except where the husband has received his share in the joint family property. Interestingly, it's still a recommendation and not the law. The obligation of a person to maintain his or her aged or infirm parents or a daughter who is unmarried extends in so far as the parent or the unmarried daughter, as the case may be, is unable to maintain himself or herself out of his or her own earnings or other property. In this section, parent includes a childless stepmother. So, the obligation of a Hindu male is to maintain his aged and infirm parents, daughter who is unmarried, and also it talks about the obligation of a person, and interestingly, for daughter it is unmarried. However, it does not put any age bar on the daughter. Only the condition is that the daughter who is unmarried. Now, suppose if the daughter is 50 years of age and she is still unmarried, whether she will get maintenance? The answer is yes. Under this section, she can claim maintenance. Section 23 talks about amount of maintenance. It shall be in the discretion of the court to determine what maintenance shall be awarded under the provisions of this act. And in doing so, the court shall have due regard to the position and status of the parties, the reasonable wants of the claimant. If the claimant is living separately, whether the claimant is justified in doing so, the value of the claimant's property, and any income derived from such property, or from the claimant's own earnings, or from any other source, the number of persons entitled to maintenance under this act. Section 25 talks about amount of maintenance may be altered on change of circumstances. So, the amount of maintenance, whether it is fixed by a decree of the court or whether it is fixed by any agreement between the parties, either before or after the commencement of this act, it may be altered subsequently if there is a material change in the circumstances justifying such alteration. So, once the maintenance is fixed, does not mean that it is fixed forever and ever. The situation changes, and if there is a material change in the circumstance which justifies any alteration, it can be changed, it can be altered. Let me give you one example. Suppose when the child is 1 year of age, the maintenance which will be provided will be different when the child will attain the age of 5 years, because the child has now educational expenses as well. So the situation has changed and it requires a change in the maintenance, and maintenance may be altered considering the changing situations. Now coming to the secular legislation. The concept of maintenance in India is covered under Section 144 of the Bharatiya Nagrik Suraksha Sanhita 2023, which is popularly known as BNSS, and under laws relating to marriage and divorce, as well as under various personal laws. The BNSS is applicable to all, means all religion, whether it's a Hindu, Muslim, Christian, or Parsi, or Jews, irrespective of their religion in our country, because it's a secular provision. Prior to this BNSS, it was known as CRPC. The previous name of BNSS was CRPC. That was Code of Criminal Procedure. And the maintenance provision was provided under Section 125 of CRPC. One of the very important provisions of CRPC it was. One of the famous cases in this regard is the famous Savano case, which was dealt with under this provision. Coming to Muslim law, parentage confers upon the child the status of legitimacy. It can be established in the natural father and mother of the child. Adoption is not recognized in the Sharia under the Quranic ruling. In Islam, the tie between parents and children can only exist between children born to a lawfully married couple. This tie cannot be established verbally or through any other contract, nor can there be a mother-son tie between a boy and a woman based on his utterance alone. If one calls someone his son or considers him so, this does not establish the father-son tie between the two. Under Islamic law, there is a system of kafala. Islamic law, instead of adoption practices, they talk about kafala system, under which child is placed under a kafil or a foster parent, which provides for the well-being of the child, including financial support, and is legally entitled to take care of the child. There are two modes of filiation known to the law. As a rule, the law treats the natural father as the natural father of the child and by acknowledgement of paternity. Now, what is acknowledgement of paternity? The name is self-explanatory. It is about acknowledgement of the fatherhood or the paternity of the child. And let me give you one example. Under Islamic law, outside marriage, you cannot have any kind of sexual relationships. That is not permissible. But suppose a Muslim has married for the 5th time. Under Islamic law, it's only 4 marriages which are valid. The 5th marriage is irregular. But once one of the wife dies or she has been validly divorced by the husband, the number again comes to 4. So suppose when it was the number of wives were 5, and that time there is a child who has begotten by this couple. In that case, once the father acknowledges that it is my child, it will be treated as that it is his child. And the presumption would be that there is some kind of marriage kind of relationship between the parties. Okay. So this is acknowledgement of paternity. However, remember that you cannot acknowledgement the paternity of a child of whom you are not the father. So this is very interesting. It actually talks about the biological relation between the father and the son type. It does not talks about adoption. It is acknowledging the fatherhood of the child, acknowledgement of paternity. The Juvenile Justice Care and Protection Act of Children 2015, the JJ Act. Section 2, subsection 2 defines adoption as the process through which the adopted child is permanently separated from his biological parent and becomes the lawful child of his adoptive parents, with all the rights, privileges, and responsibilities that are attached to a biological child. Section 2, subsection 9 of the JJ Act 2015 defines the best interest of child. It means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So, the best interest of the child and the welfare of the child are the guiding principles on which the entire adoption law is based. Coming to the new section, that is coming to a very landmark case based, mostly to say, because this provision is not there under the Muslim laws. Muslims don't talk about adoption, they don't permit adoption. We have discussed that only kafala and acknowledgement of paternity are the concepts which are to some extent coming closer to adoption kind of concept. There was a case of Sabnam Hashmi versus Union of India. This case came in the year 2014. In this case, the Honorable Supreme Court observed that though the concept of adoption is prohibited under Muslim law, the JJ Act of 2000, as amended in 2006, is a secular and enabling legislation that has been enacted for the welfare of children. It enables any person to adopt a child. The existence of Muslim personal law will not prevent a Muslim to apply under the JJ Act. So, though your personal law may or may not permit adoption, but the secular provision of JJ Act is applicable to all, and irrespective of any religion they belong, if they wish to adopt a child, they can go ahead under this provision. Thus, a Muslim may choose to be governed by personal law and may not adopt a child because their personal law does not grant it, or he may choose to be governed by the Act of 2000 and may adopt a child, that is the JJ Act, the secular law. So far as the position is concerned today, a Muslim may choose to be governed by the JJ Act of 2015 and take a child into adoption. So, this JJ Act initially came in the year 2000, then it was further amended in 2006. After that, it was changed, the entire act was repealed, and a new act, JJ Act of 2015, it came. And currently, this Juvenile Justice Care and Protection of Children Act 2015 is the applicable law for us. And under this legislation, a person belonging to any religion may take a child into adoption. Coming to Christian law, there is no specific statute enabling or regulating adoption among the Christians in India. Here too, adoption can take place from an orphanage by obtaining permission from the court under the Guardians and Wards Act. In Phillips Alfred Melvin versus T.J. Gonsalves case, the Kerala High Court held that it is an admitted fact that the Christian law does not prohibit adoption. Also, canon law recognizes adoption, and adoption by Christian couple was therefore declared as valid adoption. Another case is Maxine George versus Indian Oil Corporation case. However, the court explained that an abandoned child fostered by a couple does not get the status of an adopted child unless the formalities of adoption takes place in the physical act of giving and taking of the child, and the giver of the child is duly competent in that role. So it is actually about the validity of the adoption. Coming to Parsi law talks about Palak system. Again, in Parsis, there is no legislation for the adoption of children by Parsis in India. In the Parsi community, the only custom that comes near adoption is to designate a Palak son. Under this custom, a widow of a childless Parsi can adopt a child on the 4th day of her husband's death, simply for the purpose of performing certain annual religious ceremonies. However, the adopted child acquires no property rights. Coming to the secular JJ Act of 2015. Thus, for willing couples, the JJ Act of 2015 should serve as an enabling secular legislation for couples willing to adopt irrespective of their religion. The child would inherit as a natural born child. The Juvenile Justice Act of 2015 spells out a detailed procedure for adoption, providing for accountability, transparency, and auditability of children entering into the adoption system. Coming to CARA. CARA is Central Adoption Resource Agency. CARA regulations would lay down norms, both substantial and procedural laws, in inter as well as intra-country adoption. Means within the country or outside the country, both are governed under CARA. It also covers within its ambit the adoption of orphans, abandoned, surrendered children, step parents, and adoption by relatives. CARA functions as information center both at the pre-adoption stage and post-adoption stage. It cooperates with the diplomatic missions abroad to watch over the welfare of children given in inter-country adoption. Adoption is a means of rehabilitation and social reintegration, the noble cause why adoption should be there in our country, in our society. The Juvenile Justice Care and Protection Act of 2000 recognized adoption as one of the ways to facilitate the rehabilitation of children. The former Act of 2000 introduced a separate Chapter 4 under the head Rehabilitation and Social Reintegration. Under it, a provision for adoption was also included as a means to rehabilitate and socially reintegrate children. Coming to the best interest and welfare of the child. Best interest and welfare of the child has been the guiding principle in deciding the adoption and custody matters, which is a progressive step in the broader perspective of having uniformity in adoption laws. India is signatory to various conventions and covenants relating to a child. For example, UNCRC. Inheritance rights of the adopted child. A child in respect of whom an adoption order is issued by the court shall become the child of the adoptive parents, and the adoptive parent shall become the parents of the child, as if the child has been born to the adoptive parents for all purposes, including inheritance rights. The adopted child is kept on the same pedestal as a natural born child and shall be subject to same rights and obligations as are bestowed on the natural born child. Coming to the conclusion and the concluding remarks are, it is important to see the adoption from the humanitarian perspective rather than through the lens of religion. For individuals unwilling to adopt for religious reason, it is suggested that personal law be left untouched. However, for those who are willing to adopt, the option should remain open. The JJ Act of 2015, it serves the citizens' interest, and it is a welfare legislation that must be resorted to by all till the time something substantial on adoption is placed on the statute books. Given the extremely high instances of child abuse in the country, it is understandable that the law on adoption has remained strict. However, the procedures should not be tedious as to discourage couples from adopting. This is also recommended by the Law Commission of India in its report titled as Consultation Paper on Family Law Reforms 2018. Now coming to few question and answers. The first question is, Kamla, a differently abled Hindu married woman, was deserted by her husband soon after her marriage. The marriage was non-consummated. After 15 years, Kamla took a son into adoption. However, the authorities rejected the claim of adoption. You have to tell that what is the reason for such rejection. The first option is a Hindu married woman cannot adopt a child. Now, this option is not correct because the Act provides Hindu married women also equal rights as a Hindu married male gets to adopt a child. So, the first option is incorrect. Second, it says a married woman cannot adopt a child without the consent of the husband under the Hindu laws. Now, this is two half extent it is correct, but it is not fully correct. So be very much careful with such kind of options. The third option says a married woman cannot adopt a child without the consent of the husband under the Hindu laws unless her husband is dead or has completely and finally renounced the world or has ceases to be a Hindu or has been declared by the court of competent jurisdiction to be of unsound mind. Now, this is the correct provision, and this option you have to choose if such question is asked. Last option is none of the above, which is again wrong answer. Coming to question number 2. Can a Hindu unmarried daughter claim maintenance under the Hindu Adoption and Maintenance Act 1956 after she attains majority by completing 18 years of age? Now, we all have discussed that in case when we talk about a son, the age is 18 years. Up till 18 only, a Hindu son can get maintenance. But when we talk about a daughter, you remember the term which the Act use is unmarried daughter. It does not put any age related to daughters. So the first option is no, as she has attained majority. It is wrong. Next is yes, till she is unmarried. This is the correct option. Option number B. Third is the Hindu Adoption and Maintenance Act is silent about this. This is also incorrect because the Act provides a provision for the same. The last is none of the above. This is also incorrect. So, if this question is asked, your answer would be yes, till she is unmarried. And what will be the age of marriage? When she will marry? That will be depending upon the facts and circumstances. But you only have to remember that till the date she is unmarried, she can get the relief under the Hindu Adoption and Maintenance Act because it does not provide any age of majority related to a daughter to get maintenance, but rather it uses the term unmarried, which if she is unmarried, she can claim under this provision. A landmark case under this provision in this regard is the Abhilasha versus Prakash case. Okay, thank you so much for the patient hearing. See you soon with my next video. Thank you.